Missouri Governor Mike Parson is defending a controversial new Missouri gun law that's caused confusion among law enforcement.
Would help improve school safety and mental health programs through the president and many Democrats, though.
And is more willing to violate our freedoms than to protect his citizens.
The United States Justice Department sent this 7-page letter to Governor Mike Parson and Attorney General Eric Schmidt Wednesday.
That went into effect in August 2021, which prevented local law enforcement from enforcing federal gun laws.
The Preservation Act does not disobey federal law or deny federal law.
After the Supreme Court recently rejected a stay that would have preserved a state's Second Amendment sanctuary statute, the E-Circuit is now scheduled to hear this issue, which could result in its total rejection. Missouri's Second Amendment sanctuary law. We're going to be talking about an 8-to-1 order that was issued by the U.S. Supreme Court and how it is impacting the state's current Second Amendment sanctuary law that's in place in the state of Missouri. The recent Supreme Court order denied a stay which would have protected Missouri's Second Amendment Preservation Act. After that denial order, this case was then sent back down to the Eighth Circuit Court of Appeals, who recently heard oral arguments in this case. They are now set to issue a very critical decision on whether or not Missouri's Second Amendment Preservation Act is in fact valid, or whether the lower court was correct in blocking this law.
Missouri Governor Mike Parson is defending a controversial new Missouri gun law that's caused confusion among law enforcement.
Asking the U.S. Supreme Court to revive a controversial gun law called the Second Amendment Preservation Act.
Late last night, the Missouri Senate passed a bill known as the Second Amendment Preservation Act with a party line vote.
The way the law is worded has some local agencies worried to talk with federal law enforcement partners.
Now, the state of Missouri has a new decision that was issued by the Eighth Circuit, and they're using it in their favor to have this case completely thrown out. Essentially, they're arguing now that the federal government cannot sue the state of Missouri and cannot put a block on the Second Amendment Preservation Act that the state passed. For some background on this case and how we wound up where the Eighth Circuit is set to decide this case, back in 2021, Missouri passed a law known as the Second Amendment Preservation Act. This law prohibits Missouri officers, agents, and government officials from helping federal agents who are attempting to enforce inconsistent federal laws, essentially laws that violate the Second Amendment. The law uses the 10th Amendment as a basis to refuse state resources, deny funding, and assistance that would be used by federal agents to infringe on Second Amendment rights. Legal battle. In reaction to this law, the U.S. government sued Missouri. The statute also established a civil remedy that allowed anybody to sue a Missouri official if they assisted in enforcing a federal law that violates the Second Amendment. In essence, the federal government claimed that Missouri's extremely pro-Second Amendment law is unconstitutional and that the government's more limited interpretation of the Second Amendment is correct. This theory led to the U.S. government suing Missouri on the grounds that the statute is unconstitutional because it is based on an incorrect interpretation of the Second Amendment. The federal government further contended that the relevant statute has enforcement procedures that effectively prohibit state officials from engaging in specific behavior. The government contended that the summary wording in the statute rendered the remaining provisions of the sanctuary law basically unenforceable. In review, the district court sided with the federal government and overturned the entire statute, establishing a preliminary injunction against all Missouri state laws. The district court granted relief, essentially shielding state officials from the application of HB 85 should they choose to participate in certain actions that would aid the federal government enact specific laws.
The Second Amendment Preservation Act is meant to prevent the federal government from banning certain guns.
That went into effect in August 2021, which prevented local law enforcement from enforcing federal gun laws.
And is more willing to violate our freedoms than to protect his citizens.
I don't think anybody wanted to hamper or should be hampering law enforcement from working together with federal agencies or state agencies.
The district court issued an injunction against the bill. The Texas abortion law, known as SB 8, was reviewed by the Supreme Court in a case known as Whole Women's Health. It shielded Texas and its officials from lawsuits because it only permits private individuals to file lawsuits based on the statute. The enforcement mechanism of the Texas law was created to make it more difficult, if not impossible, for the law to be struck down in its entirety. The Missouri law is similar to another law that was passed in another state. Legal challenges. You can't get a universal injunction against the state or an attorney general since those individuals in the state at large aren't actually the ones enforcing the law. Instead, you would need to get an injunction against the individual persons who are suing under the law. But again, a different person could pop up, bring a new lawsuit, and then you would have to get an injunction or some sort of relief against that new person, and it goes on and on. The Supreme Court found that since the Texas law is not enforced by the state or its agents, then you cannot seek an injunction against those individuals. You also couldn't even get an injunction against a judge who hears one of the lawsuits, or even the law clerks or the clerks of the court who help with those lawsuits. So that's a backdrop of what Missouri did, in a similar structure that was in place in Texas, that also has a similar type of mechanism where private individuals are the ones bringing the lawsuits.
A judge has ruled Missouri's Second Amendment Preservation Act is unconstitutional.
The United States Justice Department sent this 7-page letter to Governor Mike Parson and Attorney General Eric Schmitt Wednesday.
Today, our focus should first and foremost and always be on how people will be impacted by the decision.
A bipartisan group of senators say they've reached a framework on gun legislation.
Now, the district court, on review of the Missouri law, struck down the entire Missouri law and enjoined the state of Missouri and its officers and agents from enforcing that statute. But again, the issue is that the state of Missouri is not actually the ones enforcing the law. Instead, the people of Missouri are. Then, Missouri appealed that decision up to the 8th Circuit Court of Appeals and also asked for the 8th Circuit to put in place an emergency stay on the lower court decision while the appeal is taking place. However, the 8th Circuit denied that emergency request for a stay. That led the state of Missouri to file an emergency application up to the United States Supreme Court seeking a grant of a stay. We got an order from the Supreme Court which denied that emergency stay in an 8-1 order. Only Justice Thomas was in favor of granting a stay to protect the Second Amendment Preservation Act. After that Supreme Court denial order, the case was then sent back down to the 8th Circuit, who has now heard expedited arguments in this case. We are currently waiting for the 8th Circuit to issue their decision. During those arguments, the state of Missouri and the representatives first argued that this entire lawsuit brought by the U.S. government was invalid because the lawsuit does not name a proper defendant. The government is suing the state of Missouri and the Attorney General, but the statute only allows private individuals to enforce this law. Therefore, there is no proper defendant in this case. They also argued during the arguments that the U.S. government cannot identify a single act that the state or its officers or agents are actually engaging in that is harming the government. Now, after those arguments, the state of Missouri has submitted a letter to the 8th Circuit on why the federal government does not have standing to sue them, based on a recent 8th Circuit decision that was issued by the same court. The state argues that since the federal government does not have standing, the entire case should now be thrown out. Missouri's defense against federal lawsuit. In this letter sent to the 8th Circuit by Missouri, Missouri says that when plaintiffs sued the governor and the director of the Department of Education over a statute that forbids mask requirements in schools unless otherwise required by law, the court concluded that the plaintiffs failed to establish traceability. Plaintiffs failed because they failed to demonstrate that the defendants had a duty to enforce the statute or that they had attempted to enforce it. In a similar vein, the U.S. has not demonstrated that the defendants have a duty to implement the Second Amendment Preservation Act, or that they have made an effort to do so. Any harm resulted from schools, not the governor or director.
For enforcing federal gun laws that conflict with Missouri law under the Second Amendment Preservation Act.
They said that they're not going to sit there and watch the federal government tell Missourians how to live their lives.
I think we'll look at the legislators, we'll look at our legal general counsels looking at things like that.
Private litigants to sue local officials for actually following any of the federal laws.
In the event that the U.S. suffers harm due to the possibility of private parties enforcing the law, the country files a federal court case seeking relief against the governor and the attorney general in the hopes that state courts hearing private plaintiff cases will find the federal opinion persuasive but insufficient for redressability, because the private litigant in this court has concluded will not be constrained by by any injunction that could be used against the state officials in the state of Iowa. The court also concluded that the plaintiff could not assert rights that it believed schools had, because that dispute was between the state and the school districts.
Time is ticking for lawmakers in Jeff City to give final approval to legislation that would nullify federal gun laws in Missouri.
Would help improve school safety and mental health programs. Through the president and many Democrats, though.
These shootings in Columbia, that's preventing us from getting the help we need at the federal level from stopping all these local shootings.
20 senators, evenly gathered from both parties, say they hope to have the bill passed sometime this month.
Preservation Act does not disobey federal law or deny federal law.
However, the U.S. has done so here, effectively asserting rights that it believes political subdivisions in Mississippi may lawfully participate in joint federal task forces, assist in the investigation and enforcement of federal firearms crimes, and fully share information with the federal government without fear of HB 85 penalties. So here, this letter submitted to the 8th Circuit by the state of Missouri essentially is pointing to a new decision in the 8th Circuit. And again, this points to the fact that the federal government cannot seek relief against states, since the state here and the Attorney General and the governor are not actually the ones enforcing the law. Instead, it's only the private individuals that are engaging in these types of lawsuits, and they are the ones that have the authority under the law. Based on this, the state of Missouri is arguing that the standing requirement has not been met by the federal government and that the 8th Circuit should throw this entire case out. Now this is very interesting. It's new developments in this case. It's new 8th Circuit precedent that was issued, and now it's being used by the state of Missouri to support their position that the federal government cannot bring this lawsuit against the state and cannot put this type of block on this Second Amendment Preservation Act that was passed in the state. That's all for this video, folks. See you next time.